There is a simple question Greenland Energy Company should be able to answer. What exactly did Greenland authorize before the company's equipment was put ashore? Not what the company expected to be authorized, not what an old exploration license might eventually allow, not what executives believed regulators would approve, what had actually been approved. That question matters because in late July, an excavator and roughly 15 shipping containers connected to Greenland Energy's proposed oil project were landed in a remote part of eastern Greenland. Greenlandic authorities later said the license holder did not have the necessary approvals before the operation began. The government issued a strong warning and the equipment stayed. That combination should concern anyone interested in Greenland's sovereignty, environmental regulation, or the basic principle that companies obtain permission before beginning regulated operations. Because Greenland Energy is not merely talking about exploring for oil, it is preparing to do it. The Texas-based company is pursuing a project in the Jameson Land Basin near Itokkotormiit in eastern Greenland. It has presented the basin to investors as potentially containing billions of barrels of prospective oil resources. That sounds enormous. But prospective resources are not discovered reserves. They are estimates of petroleum that might exist and might someday be recoverable. An exploration well is necessary precisely because nobody yet knows whether commercially producible oil is actually there. That distinction matters when promotional language begins racing ahead of geological reality. There is another distinction that matters just as much. Greenland stopped issuing new oil exploration licenses in 2021, but Greenland Energy's project is connected to older rights held through White Flame Energy, a subsidiary of 80 Mile. That means the company is not simply trespassing into an area where no petroleum rights exist, but an underlying exploration license does not mean every activity connected with that license is automatically authorized. A license can give a company certain rights while still requiring additional government approvals before equipment is landed, transported, stored, used, or moved toward a drilling location. And according to Greenland's government, necessary approval was missing when the July logistical operation began. That should have consequences. At minimum, Greenlandic authorities should prevent the equipment from being used or moved farther toward the proposed drilling site until its legal status is completely resolved. If the law allows authorities to temporarily impound equipment associated with an unauthorized operation, that option deserves serious consideration. Temporary impoundment is not the same thing as confiscation. That distinction is important. A government cannot simply convert private equipment into public property because officials disapprove of a company. Permanent forfeiture requires a legal basis, evidence, and due process. But authorities do not have to choose between permanently confiscating equipment and doing nothing. They can potentially prohibit its use, they can restrict its movement, they can investigate the circumstances of its arrival, they can impose penalties where legally justified, they can require unauthorized equipment to be removed, and if serious violations ultimately satisfy the legal requirements for forfeiture, confiscation can then be considered through the proper process. The immediate priority should be preserving Greenland's regulatory authority, because this was apparently not the project's first problem involving permission. Earlier, a Greenland Energy representative told local residents that the company had authorization to bring drilling equipment ashore. That turned out not to be correct. The company later acknowledged that its communications had created confusion. Chairman Larry Sweets attributed the problem to excessive enthusiasm, but permission is not an ambiguous concept. A company preparing a major Arctic oil operation should know whether a government has authorized a specific activity before telling the people who live there that permission has been granted. Then came July. Equipment actually arrived, and authorities said necessary approval had not been obtained before the operation started. One incident can be a misunderstanding. Two incidents involving the same fundamental question, whether permission exists, justify much closer scrutiny. If you value investigations that distinguish documented evidence from corporate messaging, subscribe. Greenland Energy is operating under intense commercial pressure. The company has raised significant capital. It has announced contractors. It has arranged drilling equipment. It has discussed October as a potential drilling date. It has every financial incentive to keep the project moving. But Greenland has no obligation to organize its regulatory decisions around a company's investor timetable. That principle becomes especially important in the Arctic. Operating seasons are short. Transportation is difficult. Weather can shut down logistics. Every week matters. Companies therefore have powerful incentives to stage equipment early. There is nothing inherently suspicious about that. The problem begins when logistical urgency starts functioning as regulatory leverage. Imagine the sequence. A company buys equipment, then contractors are hired, then a vessel is booked, then machinery is shipped, then equipment is landed near the project, then hundreds more containers are prepared, then investors are told that drilling is approaching. At every stage, stopping the project becomes more expensive. Eventually, regulators are no longer evaluating a proposal on a blank sheet of paper. They are evaluating a project surrounded by millions of dollars of sunk costs and expectations. The physical presence of equipment changes the political environment, even when it does not change the law. That is why governments regulate mobilization in the first place. Companies should not be allowed to manufacture inevitability, and Greenland Energy's next logistical move could be much larger. A company representative has discussed a shipment involving roughly 300 containers of drilling equipment expected to travel from Canada. 300 containers fundamentally changes the scale. If that shipment moves while essential approvals remain unresolved, Greenland could find itself confronting an industrial operation already positioned for deployment before the regulatory process has reached its conclusion. Authorities should establish the rules before that happens. They should publicly explain what authorization is required for the next shipment, whether the equipment already landed may legally remain where it is, whether it can be moved, and what penalties will apply if another operation occurs without advance approval. Greenland Energy should also publish the authorizations it says support its activities. Transparency would resolve much of this controversy. If the company possesses valid authorization for an activity, show it. If authorization is still pending, say so. If an old exploration license provides a particular right, identify that right. If a separate logistical permit is required, distinguish it from the exploration license. The public should not have to decode corporate announcements to determine whether Greenland has actually approved something. The government should publish its side as well, subject to legitimate confidentiality restrictions. Which approval was missing? When was the application submitted? When did authorities learn that equipment was moving? Did officials know the barge was approaching? Who made the decision allowing the equipment to remain? Is the equipment legally immobilized? Can it be removed? Can it be transported inland? Were customs or environmental requirements implicated? Those answers would tell us whether the July operation was a paperwork failure, contractor error, misunderstanding, or deliberate attempt to get ahead of the regulator. Until those facts are established, the safest legitimate response is straightforward. Freeze the situation. No movement toward the drilling site, no use of the equipment, no assumption that its presence creates any right to continue. Investigate first, then decide. This becomes even more sensitive because the project does not exist in a political vacuum. Donald Trump has repeatedly spoken about bringing Greenland under American control. Greenlandic and Danish leaders have rejected that proposition. Greenland is self-governing, and decisions concerning its mineral resources belong to Greenlandic authorities. Greenland Energy is an American company whose leadership has connections to people within Trump's political orbit. That deserves scrutiny, but it does not justify inventing evidence. There is currently no demonstrated basis for saying Trump ordered Greenland Energy to enter Greenland. There is no demonstrated basis for saying the equipment shipment was secretly organized by the United States government. There is no demonstrated basis for describing this oil project as a covert American invasion. Those claims would require evidence we do not have. The real facts are serious enough without them. The President of the United States has publicly challenged Greenland's geopolitical status. An American oil company with political connections is pursuing a potentially valuable resource project there. A representative of that project previously made an incorrect claim about having permission. Equipment connected to the project was subsequently landed during an operation that Greenlandic authorities say lacked necessary approval, and the company continues preparing for drilling. That is enough to make rigorous enforcement essential. The appropriate response to political sensitivity is not political retaliation. It is equal application of the law. If a Greenlandic company had landed regulated industrial equipment without necessary authorization, the rules should apply. If a Danish company did it, the rules should apply. If a Chinese company did it, the rules should apply. And if an American company connected to politically powerful people does it, exactly the same principle should apply. That is sovereignty, not speeches, not flags, administration, permits, inspections, enforcement. The ability to tell somebody with money and influence that the answer is no until the law says yes. There is also the environmental dimension. Jameson Land is not an ordinary industrial district. It is a remote Arctic environment near communities where hunting and the surrounding ecosystem remain important parts of life. Any oil exploration campaign there carries risks that deserve serious evaluation before drilling begins. The region also intersects with environmentally protected areas and international conservation obligations. That does not automatically make petroleum activity illegal, but it makes procedural discipline even more important. Environmental review cannot function properly if companies are already establishing operational infrastructure while authorities are still considering whether and under what conditions activity should proceed. The process has to remain meaningful. The same applies to consultation with local communities. Residents should not learn what is happening because equipment appears on shore. They should be able to understand what is proposed, what government has approved, and what remains undecided. There are reports that some local hunters have discussed opposing future activity using small boats. Whether anything like that actually occurs remains uncertain. But Greenland should not allow a regulatory dispute to evolve into a confrontation between local residents and contractors. That is another reason authorities need to act early. The government, not residents in small boats, should enforce Greenlandic law, and enforcement must be clear enough that neither side has to guess what is permitted. There is also a media component. Phil McGraw's Envoy Media announced plans for a documentary series following Greenland Energy's exploration campaign. Promotional material framed company executives as modern-day wildcatters undertaking an Arctic adventure. That framing becomes complicated when the project has not yet obtained every approval it needs. There is nothing inherently wrong with documenting an oil exploration campaign, but a production created in partnership with the company being documented should not be confused with independent investigative journalism. That distinction matters because narratives create their own form of momentum. Investors see an exploration story, viewers see adventurers, contractors see a project moving toward execution, politicians see economic opportunity, and eventually the project can begin to feel real before the government has made the decisions that legally make it real. Again, inevitability becomes leverage. Greenland should refuse that premise. The company's money does not constitute approval. Its contracts do not constitute approval. Its documentary does not constitute approval. An excavator sitting on Greenlandic territory does not constitute approval. 300 containers would not constitute approval. Only Greenland can provide Greenland's permission, and if equipment arrived through an operation that violated Greenlandic requirements, authorities should not allow its physical presence to become an advantage. That is why impoundment deserves consideration, not as revenge, not because the company is American, not because Donald Trump has made offensive claims about Greenland, and not because oil exploration itself should automatically be prohibited. Impoundment can be a neutral enforcement mechanism. It preserves evidence, it prevents unauthorized use, it stops the applicant from benefiting from a potentially unauthorized action, and it gives regulators time to establish the facts without another deadline being created by the company. If an investigation determines that no legal basis exists for holding the equipment, release it subject to whatever valid conditions apply. If violations occurred but do not justify forfeiture, impose the appropriate penalties or require removal. If serious violations meet the legal standard for confiscation, pursue that remedy through due process. What Greenland should not do is allow uncertainty itself to benefit the company. The default cannot become, the equipment stays operational unless government proves immediately that it should leave. The burden should remain where it belongs. The company seeking to conduct regulated industrial activity should demonstrate that it possesses the required authorization, and the same principle should govern the larger shipment reportedly being prepared. Before another barge unloads, Greenlandic authorities should know what is coming. They should know who owns it. They should know where it will be landed. They should know where it will be stored. They should know what permits cover it. They should know whether environmental conditions have been satisfied. And the operator should have written approval before the operation begins. If those conditions are not satisfied, the shipment should not be unloaded for the project. This is how Greenland avoids the larger crisis. Because the worst moment to decide what your law means is when a drilling rig, hundreds of containers, crews, and contractors are already waiting on shore. The decision has to come first. That is ultimately what this entire controversy is about. Order. A company proposes an activity. Authorities evaluate it. Environmental requirements are applied. Communities are consulted where required. Permission is granted, conditioned, or denied. Then the company acts. When the sequence becomes company acts, government investigates, permission follows later, something fundamental has changed. The applicant is beginning to control the timetable. Greenland cannot allow that. The July operation should therefore become a line in the sand. Investigate exactly what happened. Secure the equipment where legally permissible, prevent unauthorized movement or use, publish the relevant regulatory record, determine responsibility, apply penalties if violations occurred, and make clear that the next shipment will not receive the benefit of ambiguity. If the company complies and Greenland ultimately approves the exploration well, then drilling can proceed under Greenlandic rules. If Greenland rejects the necessary approvals, the company must accept that decision regardless of how much money it has already spent. And if Greenland determines that laws were deliberately violated, enforcement should be strong enough that ignoring authorization is never cheaper than waiting for it. That is the deterrent principle. The company should never be able to calculate that moving first is financially rational because the worst consequence will be a warning after the equipment is already in place. Rules that are cheaper to violate than obey are weak rules. Greenland has an opportunity to demonstrate otherwise. This does not require hostility toward the United States. It does not require confiscating property without process. It does not require accepting every allegation made about Greenland energy. It requires something much simpler. Treat permission as permission. Until it exists, the answer is no. And when a regulated operation proceeds without it, investigate and enforce. The most important fact in this story is therefore not how much oil might exist beneath Jameson land. It is not Donald Trump, it is not Dr. Phil, it is not Nasdaq, it is not even the excavator. The most important fact is that Greenland still possesses the legal authority to decide what happens next. Whether that authority remains meaningful depends on whether it is exercised before corporate momentum turns a proposal into a fait accompli. Greenland Energy may ultimately receive permission to drill. It may discover oil. It may discover nothing. Those questions belong to the future. The question in front of Greenland today is more immediate. When a company acts before receiving necessary approval, who controls what happens next? The company or Greenland? Everything that follows should make the answer unmistakable. Greenland does. If you want more investigations that separate corporate ambition, political narratives, and documented evidence, subscribe.